The small estate affidavit in Colorado. What is a small estate affidavit? A small estate affidavit is a sworn statement of a person who considers themselves eligible for getting inheritance by the descendant who left assets of value less than a state statutory limit. The document is considered an option for those whose close ones died not owning enough property to qualify for probate according to their state laws. The affidavit might also be used by the creditor of the descendant proving the debt on oath before the court. A small estate affidavit might concern any property left by the descendant: bank accounts, jewelry, art, vehicles, money, and real estate in some cases. Typically, a small estate affidavit is used when there is no last will. However, some states allow the use of an affidavit in conjunction with the last will, depending on certain legal requirements. In all states, such a document requires attestation by a notary public or other official authorized to administer oaths. Why do I need a small estate affidavit? If your spouse or parent has died, such a document will help avoid long probate court proceedings and associated costs and take possession of the property left by your close person immediately. Having the affidavit form accepted by the local probate court, a claimant can require a bank or other entities or people who currently possess the estate previously owned by the descendant to give it away to them. However, in certain situations, it would be wise to first seek legal advice before filing the small estate affidavit form. For example, when the beneficiary has not reached the age of majority or is disabled, when chances of a will contest are quite high, when the descendant has left unpaid debts, or when it is impossible to create a comprehensive list of the descendant's property and assets. A few words about a small estate affidavit process in Colorado. First of all, you should wait 10 days after the descendant's death before you can start a small estate procedure in Colorado. Then, you should make an accurate list of the descendant's personal property, excluding real property, and its fair market value to make sure the total amount does not exceed $70,000 according to Colorado legislature. Furthermore, there shouldn't be any appointment of a personal representative pending or granted in any court of any jurisdiction. To be able to transfer the claimed property to your name without a long probate process, fill in the small estate affidavit form JDF 999 that can be found on the Colorado Judicial Branch website, or, if the descendant owned a vehicle only, form DR 2712 that is provided by the Colorado Department of Revenue. Colorado law does not require you to file a small estate affidavit with the court. Instead, you should present the document to any person that is indebted to the descendant or has possession of the descendant's tangible personal property.